Let me welcome my guest for this morning, Victoria Bright, is international corporate lawyer and entrepreneur. Hassan Tampuli, to my extreme left, is the MP Gushangu and Deputy Ranking Member, Constitutional and Legal Affairs Committee of Parliament. Theophilos Jimaga Jr. is lawyer, he's engineer, and member of the NDC National Communication Team. Joining us via Zoom is Dr. Atta Kennedy, physician and political activist. Ladies and gentlemen, thank you very much for making time to join us on this Ghana agenda. Now, the special prosecutor finally files, charge sheet in the courtroom, a very lengthy one with as many as 78 counts. Ken Ofori-Atta alone has to wriggle himself out of about 28 or so, and this is the biggest story. Question is this a lost cause, as the critics are saying? Because Ken Ofori-Atta is not available and doesn't appear is willing to make himself available. Do you see this as a lost cause? Let me go first to the physician before he gets influenced by these lawyers and their thoughts with legal technicality. Dr. Atta Kennedy. Hello, Doc. Please unmute your mic.
Good morning.
Yes, we can hear you clearly. Good morning, Doc.
Good morning to you and your eminent panel. I want to associate myself with your opening comments about the culture of impunity and how we do nothing about things. I have watched the young woman's video about the abuse, and I have been ashamed as a Ghanaian about how our law enforcement agencies and responsible officials have watched things like abuse, the deaths of those who are going to try and get into the military. One of my friends has a joke. He says that Japanese who commit offenses against their state commit suicide. Chinese are executed. The Russians check to find out whether Putin is okay, and Ghanaians wait by their phones to hear announcements of their next promotion when they do something wrong. So that's where we are. I think that you brought me in to make our friends who are lawyers look good.
The police
I feel
station,
a little lost.
The police station where the lady reported to about twice, and there is evidence to that effect, and she was completely ignored until she was almost murdered, except that she got rescued by this person who was bold enough to take the video and also testified that she has been suffering this battering all the time. That police station should be collapsed by this morning, right?
Yes. I think there is something to be said by people for people's justice. I am disgusted by it, and I think that if nobody at either police station, whether of Fango or Tesano, is punished for this, I will be very disappointed. But Samson, we've made a habit of distance. The people who died. I noticed that the deputy defense minister resigned. That is a reality in our history and our body politics.
Well, we're told that was a fake letter. So he hasn't resigned. Nobody has been held accountable yet. Everybody is cool. This morning they are having Wache waiting for the next session.
There ought to be some accountability.
That was complete negligence. Complete incompetence.
Absolutely.
It was so predictable.
Absolutely.
You invite over 21,000 people to a stadium that can accommodate only 7,000 people. You invite them all on the same day at the same hour, and you provide only 6 decks to attend to them. What do you expect?
Yes.
And we are fine. We are fine. Life is moving on. This country.
Yes.
Okay.
It is demoralizing. But let me continue about Ken Ofori-Atta's case and the idea that it's a lost cause. It is not a lost cause. For one thing, even if he's not in Ghana or in the jurisdiction. There can be a trial. He has lawyers who can defend him. There can be verdicts about guilt or innocence. And even if he doesn't spend a day in jail, the fact that he finds it necessary to avoid going back home, there is also shame and opprobrium, and hopefully it has a deterrent effect. So it is not completely a lost cause. And of course, there are extradition procedures. If he is convicted, that can bring him home. So I do not
but the extradition
consider this a lost
the
cause.
extradition procedures may fail. It is the red notice that he was put on that has put him in his cocoon. He's unable to move anywhere because there was a red notice. That red notice has now been redacted, or as it were, suspended, because he has made at least 2 applications seeking to reverse that red notice on him, so he can move around the world.
Yes. I think our judicial system and justice has a long way to go. But Samson, the bigger issue, though, is that we do this curative justice. It is not as if we woke up one day and just found out that all these things had happened. These things were happening in slow motion, the SML deal, the loans that were syndicated or handled by firms that were associated with him and his friends, Parliament sitting by where it had not granted approval for him and his cronies to do things. It would seem as if your government is in power in Ghana, you can do whatever you want. And this has given the administration of our justice a very unfortunate partisan tinge. And sitting here, I have a feeling that if, God forbid, Dr. Bawumia were president today, maybe Ken Ofori-Atta will not be facing a lot of the headwinds he's facing today. And that is a very telling indictment of our judicial system. So I think that we need to do more to prevent some of these crimes instead of wait for them to happen and then go on these futile exercises to try and exact judicial punishment when administratively we could have prevented a lot of
There's
them.
an attack on the special prosecutor, and as we understand, there's a reverend who is going to organize a demonstration. It was supposed to be done by Martin Pebu, but he has taken the lead against the special prosecutor for sitting by and watching the OSP, the OSP watching the SP, not the OSP. The OSP is the office. The SP is the man at the top. And watching Ken Ofori-Atta leave the country in January. And Martin's argument is simple, that once he became aware, even if he didn't get assistance because the Ofori-Atta's government was in place, he should have organized a press conference and Ghanaians would have massed up at the airport and stopped him. For not doing so, he's incompetent and he has to resign. What say you? President Akufo-Addo, let's remember he cancelled about 2 of the contracts at the initial stages after the KPMG audit. Now, after the OSP's work, the President John Mahama has also cancelled the rest of the contracts, and we are told that the value of the cancelled 5-year upstream contract is about $3 billion.
We don't know about whether, without formal charges, he could have prevented from leaving the country. But I think there is value in your point that it will seem as if, as long as the Nana Akufo-Addo government remained in power, Ken Ofori-Atta was untouchable, and so were quite a lot of other people. I think we need to move towards a justice system where, regardless of who is in power or whatever your position is, independent agencies or supposedly independent agencies like the OSP can go after people. After all, that is why the OSP was set up in the first place, so that it could resist political pressure. But to be honest, though, even the Attorney General's office in a country that is serious ought to be able to go after people. After all, that is why the United States brought the idea of special counsel. Clinton was president when the special counsel was named to investigate him. We've seen that Trump was also in office when one was named to investigate him. We need to move away from this system where being an incumbent seems to insulate you from judicial processes and you can do whatever you like with impunity. In effect, we seem to be practicing serial one-party dictatorships that last 4 or 8-year terms. And then once that is over, then the other party comes and they make noise about how we are shocked about why all these things happen. So where was Parliament when these things were happening? Well, there are a lot of people who have questions to answer as to what happened. And remember how a lot of even MPP MPs wanted Mr. Ofori-Atta removed, and for a whole year, all of them couldn't get one person removed. And in effect, if we are talking about the sins of Ken Ofori-Atta, he was reporting to somebody. I think at some point we need to be asking the president, the former president, questions about what he was doing while his ministers were looting our coffers dry. I think he has a moral responsibility to be asked to address some of these things.
I don't know what Vicky wants to say. Is it a lost cause? And as someone, as a lawyer, 78 counts. That's historic. I think it was in Gloria Kufuor's time that we have a charge sheet that had over close to 50 or so counts, and we're like, whoa, this never happened before.
Yes, I mean, when I saw the number of counts, I was.
Of course, they're against 8 people.
Yes, but still, there's I think it must be historic, as you said, because post-Glorious time, this is the highest number that we've seen. I think that the whole OSP argument is becoming increasingly uncomfortable and difficult for the OSP because the public for a long time has made it clear that they feel that it has a legitimacy and a credibility issue. There was an overwhelming support, and for various reasons, that has now gotten to where it has gotten to the point that now you could see that that whole thing has turned into a bit of a credibility deficit. And so there's now a credibility deficit at the OSP, and they have to work hard. They really have to work hard to repair that deficit because it's widening. So that is my starting point.
So explain that to the ordinary listener. What's this thing about the credibility deficit at the OSP?
Yes, because, to normal Ghanaians, their money allegedly has been stolen. That's how they look at it. They want the money back. The OSP has been given a mandate to aid in recovering that money and to punish the alleged or anyone who's found to be culpable.
Over 1.4 billion?
1.4 billion.
At stake.
At stake. It's a lot of money. There are people starving, there are people dying in hospitals, etc., etc. So it's an anti-corruption fight. And the state of corruption in this country has been shocking, nothing short of shocking. And at times you sit there and wonder whether things will change in our lifetime. I am someone who looks at the glass half full, so I like to think that things will change. And the point of the credibility deficit is that without that, how do you actually present yourself as the czar fighting this thing? Because it's huge. It's mammoth. And so for you to actually fight, you need the support of everyone. The institutions, the people, everybody has to be on board. And for everyone to be on board, you need to be seen as a credible fighter against this animal that we are all facing, against this canker that is engulfing and killing Ghana. in all directions. You know, so credibility then becomes so important. And so when you see that that credibility is weakening, or it's creating a gap or a deficit, you have to quickly move to repair it. Because if you don't, then the office becomes toothless.
So that's what I want you to speak about. What is it? That the accusations that I've heard someone say that this is a grand scheme to let Ken Ofori-Atta off. So the office watched for him to escape out of this country. And now they have put the charges, they may do everything in his absence and so on and so forth, and he doesn't get to suffer anything really. But of course, Dr. Atta Kennedy disagrees that he doesn't suffer any reputational damage or something.
Yes, I mean, I also, just to comment on that last point, I agree that you don't, you know, you do suffer because you are now, if the person is convicted, they become a convicted criminal, a felon. So that obviously is not anything that any of us would want against our character, especially someone who has held such a high and very critical office.
So back to the credibility issue, that this is a scheme to let him off the hook?
You see, I don't know whether it's a scheme, but that is the perception. And this is what I mean by a credibility deficit. Okay. Because that is now the public's perception, rightly or wrongly. Because look, here we are, 78 charges. And that is where our focus should be. And instead, where is our focus? The focus is on the fact that the former minister was allowed to leave the country. So the focus has shifted from where it should be. But
that's not the OSP.
Where we are now.
So that's not a question of credibility to the OSP, right?
No, I'm saying that the perception that we have, or that the public has now led to a shift by the public into looking at the wrong thing, if you like, instead of, you know, 70. I mean, this is a serious, and for us lawyers, it's historic. And for any ordinary Ghanaian to be told that 8 people have had 78 charges proffered against them, I mean, that is a very serious matter, whichever way you look at it. And, you know, so the OSP's office is meant to be built on fearlessness and independence. That is it. I mean, that was the whole point of having this office. So for Ghanaians to perceive that he watched, you know, as Ken freely left, is causing an institutional state.
That's not a perception. That is he saying so. That they saw him leave. Literally, he said they saw him leave, or they watched him leave, because they were powerless and they couldn't do what had to be done. They needed support from other institutions, and it was practically impossible to get the support at the time when Ken Ofori-Atta's government was in place.
Yes, and I think we need to be a bit sympathetic to that argument from the OSP, that he leaned on all these organizations and they didn't support him. However, he himself has powers.
Correct.
He himself has powers.
He's got powers, so police powers to arrest.
He has all those powers.
And Martin Pebu say at least he should have done a press conference, and the public would have run to the airport and stopped him.
Well, press conference, yes. Public running to go and grab him. That one we need to tread with caution, because imagine it could have easily deteriorated into a mob situation. But I do agree that he should have held it, because he's very good at doing these press conferences. I mean, he keeps telling us this, that, and the other. So that should have been perhaps the first press conference that he should have done.
So that if he became aware this morning, what's the time now, is 9:40, thereabout, and he's got information that Ken Ofori-Atta is at the airport, maybe immediately by 9:45 or 9:50, he would have organized a press conference, and that would have stopped him.
Yes, because he had prior notice. He had prior notice. If he didn't, that would be a different thing. So you know, you cannot blame people for holding that viewpoint. And I don't really know how.
And for not doing that, he's incompetent, so he ought to check out of the office.
Well, you know, in Ghana, as you said a short while ago, nobody resigns on any ground. I mean, look at what happened in Elwak, which we were talking about. If anyone should have resigned, it should have been then, instantly. But here we are. People are eating their wachi and their kenke and carrying on as usual. That is the Ghana that we have today, sadly, you know. So for me, we have now, that by his inaction, we have now found ourselves in a position where someone who he believes he has questions for, and serious questions, and who is uniquely placed to answer those questions, is not actually in the jurisdiction. And you are now trying to bring the person back. I mean, look, self-preservation is a very important thing. So who in this situation is going to come back willingly?
Do you recall what Ghanaian said when he attempted to, the office attempted to have him, you know, come to answer when he gave the excuse that he was not well, he was receiving medical treatment? The public said he was being heartless, he was not being compassionate, and that he couldn't be treating such a notable figure that way. I
mean, look, health, human health, our health is all we have.
So what do we want? What exactly do we want? If we say he escaped, and we have gotten to know that he was going for medical help, and the man was going to go after him then later, and we said you don't do that to someone who is unwell, and now we say you let him go, and he says we were unable. Now we say, what do we want?
So if he was going to go after him over there, because the horse had already bolted, right? So if he was going to go after him and he was there, and now he sees him walking around in Washington, D.C. or wherever, and he wants to go after him, then he should go after him. He has the resources, to go after him. If he truly believes that there are serious questions that need to be answered, and the former minister is uniquely placed to answer those questions, because look, he was the guardian of our public purse.
From where you sit and what you know, from where you sit and what you know, is the Ken Ofori-Atta being pursued by the OSP?
Well, I don't see any pursuit.
Okay.
I don't see any pursuit. I see a lot of rhetoric. I see a lot of press conferences. But in terms of actions, I don't see...
What sort of action, for example, beyond issuing the red alert, the red notice, getting him, stopped and limiting his movement, and all of that?
People from his office can go to the US and talk to him. He also offered to, I think, do Zoom or whatever.
Okay.
So there are various things that could have also been done to help maybe expedite us getting to this stage. Because yes, now there are charges, but maybe those charges may have come earlier. Assets could have been frozen if arrests had been made. Because right now, look, the way the world is, if you're dealing with people with sophisticated financial nous, and you've waited, 10 months, 11 months, if someone wants to get rid of their assets, by now, they would all be gone.
Okay.
So you are fighting a Pyrrhic, whatever victory you secure will be a Pyrrhic victory. Asset freeze is the first thing that you do. The first thing that you do. And if you have to arrest someone...
The suspicion is that by now, Ken Ofori-Atta and those who are being pursued would have concealed their assets or sold them off?
Highly intelligent people. I don't know what they've done, and I'm not here to suggest that they've done one thing or the other. But what I am saying is that anyone with any financial nous, and we are dealing with very sophisticated, intelligent people, is not going to sit there and watch, for 11 months and wait for government to come for them or the OSP to come for them or whoever to come for them. As I said, self-preservation.
So from where you sit, it is too late in the day now?
Well, I don't know. I guess we will find out whether the assets are still there or not.
Okay.
We will find out. I don't know whether there are any plans to do that. I don't know what the OSP's, plan is. And there are a lot of questions now, given everything that we've looked at, about their tactical, how do I put it? The options that they've chosen tactically to get here, or let me say thus far. There are a lot of question marks on those tactics, I think.
Help us understand. What are the tactics that there are question marks about?
So what I mean is that, as I was saying just now, we could have gotten to this place quicker. We could have taken advantage of the former minister offering to actually have a dialogue. His lawyers are here. He said all communications can also be passed through the lawyers. I don't know how much advantage the OSP has taken of that whole situation. People could have been sent over there to speak to him. So there are various things that could have been done. And as I said, assets could have been frozen.
Is that how criminal prosecution is done? That the suspect is away abroad and then you have to go to them and then
no, of course
speak to
not.
them?
Of course not. Of course
so
not.
Why was this supposed to be, you know?
He is supposed to come, or
right?
He wasn't supposed to leave in the first place. But as I said, the horse has bolted. So now you are trying to do damage limitation.
Okay.
So how do you get the information? You have to get it somehow. You have to get it somehow.
Okay. So you compromise your position, compromise everything because this is a different kind of suspect. Yes, Theophilus, what do you say?
Compromise, not
yeah.
compromise.
Okay.
Samson, it's only that Vicky had been a bit diplomatic when you were asking about the credibility deficit thing. I mean, the truth of the matter is there's a problem with the SP. People don't trust him. Yes, we all need to support him to be successful.
Right.
But before then, Sedina had about 80 counts. So the 78 is not...
right.
Yes,
right.
Sedina had 80 counts.
Okay.
Then also, you remember a certain Mr. Tevi of the NCA
Yes,
case?
NCA.
He was on dialysis, but he was questioned. You remember a certain Dr. Anemana of the Atufosin case? He had health problems, but he was attending court until the AG entered nolle prosequi. Look, what was the strategy?
What do you mean? They were out of the country?
No.
And the officers were going there?
No, they were here.
So what's the comparison about?
Yes, I'm coming to address the issue. What was the strategy of the SP?
Okay.
Now, he said the finance minister left between 3rd and 7th of January. That was when he had a problem. He could have arrested him. He could have gone to court. He could have gone and asked the court to ask him to deposit his passport because he's a flight risk. And within that time, when there's a change of government, assuming we want to believe him that what he was telling us was the truth, that he tried and wasn't getting cooperation. If he had arrested him, no one from that government, the erstwhile government, would have said that, hey, don't arrest him. He would have arrested him by then. He would have sent him to court. He would have gotten the court to say, deposit your passport. He would have told the court that the man is a flight risk. And the court would have agreed with him, would have erred on that side and said, deposit your passport, and would not have run away. You see, currently, the SP is telling us that the prosecution, that the interior prosecution, Samson, help me here. Article 19.3 says that criminal prosecution shall take place in the presence of somebody who is charged with a criminal offense, unless the person decides not to be available when he's notified of it. Frank Davis tells us that he have not been notified. Now, so if we go on now and go for the trial and secure conviction, where are we getting to? Before we even go on to the trial, the judges will have to make sure that the person has been notified of the charges. How is the notification?
When were the charges filed?
I think last week.
Last week?
Or last 2 weeks, yes.
If you have a copy, you can look at when the charges were filed. And then you may answer also when Frank Davis says there has not been notice.
Frank Davis was telling us a few days ago that he's not been notified. They've not been notified of any.
Was the very same day the charges were filed?
Yes, that they've not been notified.
Yes.
Now, my concern is...
When you say day, who do you mean?
Frank Davis speaking for the
accused person, the suspect,
said that, well, his client has not been notified.
Okay.
You know, and I know very well, as I quoted, that he has to be notified before he attends court. Now, if he's not notified, how is the trial going on in his absence? If we compare it with the Sedina case, Sedina was already in court before she asked permission to travel out of the country. So we could safely say that she was notified. Assuming even that they have gone by the other way of criminal...
The charge sheets.
Yes.
Was filed on the 18th.
Yeah,
correct.
Of November.
Of this month.
Yes.
18th was which day? That was Tuesday.
Yes. Okay.
Frank Davis spoke which day?
I don't have that.
Same day?
Same day, yes.
And the next day?
Yes. So already Ken was out of the country.
No, you said that he said he had not been notified.
Yes.
And that tells you that they are not working, they are not doing their work. They should have notified him.
Yes, no, I am saying that how was he
from your work as a lawyer?
Yes.
A charge sheet filed by 18th.
Yeah.
Is this sufficient to accuse the office
No.
Of not having notified the person?
Not at all.
In less than a week?
No, not at all.
So why do you buy the Frank Davis story?
No, I didn't buy the Frank. I'm making a case that, assuming now, how are we going to notify him? That's my question.
Okay.
Are we going to notify him by post? And the Constitution says that you bring the thing to the person's notification. What type of notification are we saying? Are we bringing it by post, by social media, or by publication in the Daily Graphic? Which one are we going to do? That is my concern.
So you educate us.
Yes. Now, if it is by criminal summons, which they would have gone to a magistrate to obtain that, yes, they could have done that by leaving it at the last known address with somebody who is above 18, or posting at the door or something over there for him to be notified. But now we have not been told whether there is a criminal summons that was initiated before this one.
Is it premature to be suggesting that they have filed but they haven't notified them? Is it premature?
It is not premature at all.
It is not premature?
It's not premature at all.
That they filed it on Tuesday?
Yes.
And so by now, there should have been that service?
Yes, I would have thought that before the trial will begin, he would have to be notified. Otherwise, we are doing nothing.
Notified of what?
Of the charges.
Which have not been filed?
They have been filed on the 18th. You just said it.
Okay.
That they have been filed on the 18th. And my question, which I don't know you have the answer, is that has he been notified of the charges?
I asked you earlier that
Yes.
as a lawyer,
Yes.
if you file charges on the 11th,
Yeah.
on a Tuesday,
Yeah.
by Wednesday, by Thursday, by Friday, is it not premature to suggest that the person who has been charged has not been
It's
served?
premature. Absolutely. I agree with you.
Then you are confusing me with what you're saying.
No, I'm not confusing you. What I'm trying to draw your attention to is that I'm asking the question you are asking me. Has he been notified? If he has not been notified, let's take steps to notify him. If we don't notify him and we go on to the trial, then we are fighting a lost cause.
Okay.
That is all I'm drawing your attention to.
Okay.
Yes. So the OSP, the SP needs our support. Yes, we need to support the SP to be successful. But he must help himself for us to help him to be successful. If it is that he has the Ken Ofori-Atta in line, he had all this before change of government, and he was he had concern that the Ofori-Atta might leave the jurisdiction. Apart from the news conference, he could have arrested him. He could have arrested him and have gone to court and asked the court that this man is a flight risk. Don't allow him to leave the country. That is my concern. But until he's not been able to do all that, he's not been able to do the press conference as usual and tell us what is happening. Yes, I agree with Martin. Martin is not saying let's all rush to the airport and arrest him. We can all rush to the airport, or the people rushing to the airport, to prevent him from leaving the country. Yes, he has not been charged with anything. All the finance ministers who had that portfolio before him have stayed in the country after change of government. They never left. Even Chachuchikata was out of the country when he was accused. He flew in and to defend himself. So if it is genuinely that, let's assume that he's genuinely innocent, and of course we should assume that he's innocent, why is he out of the country? Now, we gave the idea about health, and I've given you examples of those people who had the health issues. They were here. You were asking me what's the comparison. They didn't travel. They were in the country. They were attending court.
No, I heard you blaming the prosecutors.
No, I didn't blame the prosecutors.
Oh, you didn't? Yes. Okay,
no,
okay.
That's not it. I'm only giving you the comparison that they were here. They were interviewed. So if it is about health and he's here, he could still be interviewed. That is my presentation this morning.
All right.
That Mr. Tevi and Anemana were both in the country. They had health issues. They were interviewed. There was no problem. So to talk about the idea that people will say, oh, you don't have sympathy for the man because the man is unwell and you want to question him or interview him. There are instances where people had problems. They were in the country and they were interviewed. So for Ken Ofori-Atta to be allowed just because it is health reason to be out and he wasn't interviewed, that to me doesn't sit well.
Who allowed him?
The previous government, what the SP tells us is that he tried to get him stopped, and he wasn't allowed to the immigration didn't help, nationals. He mentioned all the people who were supposed to help didn't help, but he has to leave the country upon seeking permission from the chief of staff, the former chief of staff and the current chief of staff, to attend medical attention. Yes, he could have drawn our attention to some of this happening, that he wants to interview this man or question this man. Then he could have invoked the idea that you're under arrest, I'm investigation ABC, and we stop him. Okay. But to have allowed him to go now, then we are now crying, I think for me.
So I asked the question that, imagine I become aware that he's at the airport. What did he say he should have done?
What should he? No, I said I agree with what Martin said.
Yeah.
Yes, we should
do a press conference.
Yes, I mean.
And you and I will go to the airport.
I'll go with you if you
go and stop him.
I'll go with you if you
okay.
go. But the fact is that Samson, Ken has to be personally notified of the charges. How are we going to notify him personally?
Are you suggesting that the people who are doing it, they don't know what they are about?
As at now, I would have thought that if I had known all they are about, why didn't they do it until the man left the country?
Oh, really? Oh, you mean in January?
Yes.
They should have filed the charges then?
They should have, even if they had not filed
when
all
did the
these charges.
Start?
When if they have not filed,
when did the investigation start?
I don't know when the investigation started, but if that had not happened, how come that he was worried about
investigations? The story broke, I think, sometime in November of
2024.
I know it was before, and then there was the KPMG report that came out, and so on and so forth. But they have told you also that they had to do some investigations, and they got SML machines and devices picked up only about 3-4 months ago, and that's what has led to them being able to finish their work.
Samson, you know and I know that there are some instances where persons are invited for preliminary investigation and investigations are not completed. You had all this, so that is why I asked the question, what was their strategy?
Okay.
Assuming they had all this in mind, the story broke somewhere in November, and potentially it looks like something which could be big. You err on the side of caution to say, let us get this man, let's caution him and get ABC done so that we stop him from leaving the country.
Thank you.
Now, after January, you are aware when they have lost power, you are aware he might leave the country.
Hassan, what do you say?
Thank you very much, Samson. Good morning.
So now we are listening to the lawyers, and I'll tax the lawyers a bit because, yes, we are lawyers. Let me hear you.
Good morning to my fellow panelists, yourself, and then to the viewers. I think we have discussed this matter before, and it's interesting that we've come back again to touch on the same subject matter. A number of issues arise, but before then, I need to put on record that some attempts to make it look like the government of Nana Addo Dankwa Akufo-Addo was not combative enough to deal with such matters, really begs the question. Because who created the office of the special prosecutor? How do you say such a person is not desirous or is not interested in fighting corruption, when indeed the first person that occupied that office, Honorable Martin Alamisi Kaiser Amidu, and a long time, Deputy Attorney General with vast experience.
Member of the NDC.
Member of the NDC. Was the first to have occupied that office. And this is not a person that somebody can control. And if you know Martin Amidu, you know this is not a person that Nana Akufo-Addo put in there in order to know that maybe it's a person who is...
How did it end, though?
Who is amiable.
How did it end?
Of course, it doesn't really matter how it ended, but the intention was to have put somebody there to do the work. And you can see from the evidence again that the current special prosecutor was put there because he is known to be fearless. And he was our lecturer, isn't it?
No, I don't.
So he was...
yeah.
So when Mensabi left, so he took over criminal law just in the middle of, my criminal law days at the law faculty. So knowing Kisi is somebody that you cannot really sit down and then manipulate. So I believe very strongly that the intention of Nana Addo Dankwa Akufo-Addo, the former president, to preserve the office of the special prosecutor and make it workable cannot be, questioned.
From the point you're coming from,
cannot be questioned.
From the point you're coming from Martin Amidu's point, knowing how he left, then will the claims made by the Kisejabing not be easily believable that during Akufo-Addo's regime...
I'll come to that.
No, you finish that point first.
I'll come to that.
During Akufo-Addo's regime, it was difficult for his office to function because I remember he saying that it was as if all the other sister organizations had been instructed not to deal with them. So he can't work with, police won't work with him, these people won't work with him. And that's the situation he found himself in. He was talking about a general situation. And we know that within Akufo-Addo's regime, there were about how many suits trying to abolish the office. There was one petition trying to remove him from office, correct?
Currently, there are about 15 petitions for the removal of the special prosecutor. Is it blamable on an
15 petitions?
About 15 petitions.
Before,
are you going to blame
President Mahama?
No, now.
Before President Mahama?
President Mahama.
Okay.
Are you blaming that on Akufo-Addo as well?
I'm not aware. 15 petitions.
So I'm telling you, it is nothing. It has nothing to do with Akufo-Addo.
Okay.
But the point that I'm trying to make is that when Honorable Ken Ofori-Atta was leaving the jurisdiction, at the time he had informed the current the chief of staff at the time, and he had also informed the transition team members, the person who was representing the current administration, the incoming administration. He had served notice on them. Now, if this was a person who was running away from justice, more or less a fugitive, I don't know who will be actively informing people that I'm leaving the jurisdiction to go and seek medical attention. That, for me, beats my imagination. Secondly, at the time that Honorable Ken Ofori-Atta was leaving town, was the OSP investigating Ken on the SML issue? We need answers to this question. Secondly, if the OSP was investigating Honorable Ken Ofori-Atta, did he actively seek the cooperation of any agency of state to prevent Honorable Ken Ofori-Atta from traveling? Because, as you know, the CID, the NIB, EOCO, FIC, OSP, routinely, even the courts, routinely serve stop notices on the Director of Immigration, Controller of Immigration, to stop individuals that are subject of investigations or suspects or persons of interest or even accused persons from leaving the jurisdiction. Was that done? Is there any evidence that a letter to that effect had been served on the controller? We need answers to those questions. Now, if he did, how did he do it? Were they letters? Or did he place call? Did he call the Attorney General, for instance? I don't want Ken to leave town. Can you do something about it? The Attorney General is alive.
Talking about the Attorney General. The Attorney General is also investigating this same matter, right?
I'm talking about the Attorney General at the time.
No, I'm just asking now. And I would like Theophilus to also respond to that.
That's right.
The Attorney General has told us that he's also investigating this matter.
Correct.
So what has he also done?
Exactly. So I'm saying that at the time, did the OSP contact the Attorney General and to seek his cooperation? And don't forget that they are mates and they are friends.
He said their doors were shut to him.
So, no, but there's no evidence.
They were like a persona non grata.
Look, in public service, your best weapon is paper evidence. Is there any evidence? Is there any text message? Can you call the then Attorney General, Honorable Godfrey Dami, to find out for him? Because this is an indictment on those people.
So let's refocus the discussion.
Let's
refocus the discussion. Is the absence of Ken Ofori-Atta, does the absence of Ken Ofori-Atta make this a lost cause? That's the focus.
No, but that is
78 charges.
That is not even the case, because the law provides.
We're discussing the charges.
The law provides for mechanism for trial of persons who have absconded or are not available to stand trial.
Okay.
But the law to continue. What's her name? Sedinam Ationu. She absconded. The trial went on in absentia, and she was convicted in absentia. You understand? But that is not even...
Sedinam Ationu.
Yes, that is the master.
She was charged.
Yeah, she was charged.
While she was in Ghana.
She was in the jurisdiction.
She was in the courtroom. And the trial was going on.
And then she left.
Then she asked for permission to travel for treatment.
That's correct.
And didn't come back.
That is correct.
Is it the same situation?
It's not the same situation, but it is similar. Because at the time Ken was traveling, he said he was going to seek medical attention. And there's evidence that Ken had...
He was not before a court.
No, not. But he was not even being investigated for SML issue. We need to find out whether at the time Ken was traveling, was he actively being investigated? No. And we need to find the evidence. He wasn't actively being prosecuted, being investigated. And when Ken left, there is evidence that Ken went to a hospital in the United States to undergo surgery for prostate cancer. And this is a man above 60, in 64, 65. And in the second week of June, he went under the knife. There's also evidence to that effect. And if the special prosecutor or the authorities within our country do not know this, then there is a problem. Because all this information must be readily available to them. Now, post-surgery, what is Ken's situation? Do we know?
Hold on.
Do we know Ken's situation?
We want answers to some of the questions.
Do you understand?
Want answers to some of the questions you guys are asking.
Very well.
I'm told that the Director of Strategy at the OSP joins us. Thank you for joining us, Samidako. Hello, Samidako. Unmute your mic.
Thank you very much, Samson.
Right. So let's begin this way. You filed the charges on Tuesday, correct?
Yes, Samson.
On the 11th.
But if you permit
hold on. Let me ask you questions before you address what you want to. Hold on. First, I say you filed the charges on the 11th, which is on Tuesday, correct?
Yes, we filed the charges on Tuesday.
Right. We're told that Ken Ofori-Atta has not been served, according to his lawyers. So what are you waiting for?
Again, this brings me back to the inaccuracy and the misinformation that we believe that sometimes is deliberate and sometimes is out of, say, ignorance, that feed into the whole idea that the OSP is probably not doing its work right, and that feeds back into the credibility issues. These are the processes that happen. So because Mr. Ofori-Atta is not in the jurisdiction, and as every lawyer is aware, when it comes to criminal law, you do not serve the lawyers of the accused person. It has to be served on the person. So we have filed the charges. We've applied for summons to serve him where he is. So that is a process. And again, this has also been a problem where people keep rushing the OSP, but the OSP will listen to people, but it does not pander to people. It follows due process and it follows law. If you recall, when we are at the investigative stage, a lot of lawyers were even saying, go to court and file charges when we were at investigative stage. And yet they were insisting, go and file. And we had told them that we were at an investigative stage. And at investigative stage, the law enforcement agency has the power to try to bring down an accused person so that it can go through the investigation and finally present the person before court. In the case of Mr. Ofori-Atta, it is one of the reasons why we had to put him on Interpol red notice, because he had given us the excuse that he was so sick. And we had our intelligence to show that he wasn't so sick and that he had been trotting around the globe. At least he's on record to have been going to the United Kingdom and Hong Kong and a few other places. And so we had to get an arrest warrant on a charge and then restrict his movement from moving across the world. So we were able to restrict him to the United States. Now, people have said that he offered us a process that we could have spoken to him and we did not take that and all that. So you see, when you are investigating someone, like someone said, what was our plan? Everybody has a plan. An investigation can take so many years. I'll give you a typical example. Americans were doing something on romance scam. It took them 6 years. We're investigating Airbus. It took OSP roughly 6 years. Ken Ofori-Atta's case, it has not even taken us 2 years, and yet we are hearing a lot of a narrative that we have sat down for everything to vanish and blah, blah. No, we have not sat down for anything to vanish. In fact, we have done this investigation in record time. Other investigative bodies are investigating Mr. Ofori-Atta for different things. Has anyone presented their work? yet. Even SML, we are told that there were other bodies that were investigating it.
I just mentioned a while ago, the Attorney General has announced that they have also been investigating SML.
Yes.
Which
so the point I'm making
involved.
is that there's a lot of unfairness against the OSP, and it's rightly so, because you see, when you are independent body and you are being pushed by the left and the right, these are what will happen. And when you fight corruption, it fights you back. The people who are fighting are so sophisticated, have money, and they're able to spread a lot of misinformation, because their whole idea is that this job rests on the trust of the people. And so if we're able to pollute the minds of the people against the body and they lose trust in it, then it won't work. Some also believe that our party is in power and we must have somebody who is within our party.
When will Ken Ofori-Atta be served with the charge sheet?
So it's a process. Currently, the court will give us a date. I mean, they gave us a date, but my understanding is that the registry has called us back and said that there have been a few issues, and so they will have to reschedule the day. So when the new date is given, those processes will be done. And like I said, in criminal matters, we don't serve lawyers.
No, that is clear. Clear.
Yeah, but it's clear. But
let's stay on this issue. Let those who want to peddle what is inaccurate go ahead. You can't stop them. You have educated, so you stay there. Could you have gone for this summons before you filed the charge sheet?
No, we couldn't have done that because we were still in the investigative stages and we couldn't have gone to court to that. That's why we had explained that.
The question that is being asked you again is, in January, when he was leaving, why had you waited up to that point when you hadn't filed charges? You should have filed charges by then.
Samson, that brings me back to the subject, and that's why it's so interesting. Sometimes you don't understand what some people want. I've just said that investigations do take a while, and SML is one of the most difficult investigations the office has done because of the complexities involved and because we needed to go to other jurisdictions for evidence and all that. And we have used less than 2 years to do this investigation. And this investigation started, the complaint came to us somewhere in December 2023. When the complaint came to us, the same December, I think getting the end of December, it's when President Akufo-Addo set up what do they call?
KPMG.
The KPMG. KPMG took about 3 months. So we had to pause and still be doing our work in secret and be getting information. They did their work for about 3 months. And then we needed a copy of the KPMG report, which we never got till it was made public, right? And it was made public somewhere in April and the rest. And then from April thereabout, we're still working, and the SP, someone had applied for his removal. He had to go through a whole impeachment procedure. Just look at the CJ going through impeachment procedure, whether she had even the presence of mind to even focus on your work. And the SP were going through all these things. Just when it was done, another petition was brought for the SP's removal, and he had to go through another impeachment procedure. So there have been a lot of bottlenecks in the course of the investigation. And so the investigation, even like I said, we've even done it rapidly than we should have done, because in such investigation, you take your time. It can even be just like Airbus. It took us 6 years. It could have taken us even 4 years. It's not about how people are so much interested in Ken Ofori-Atta. It's about we following due
You should
process,
have organized a press conference when you heard that Ofori-Atta was at the airport.
When we organize press conference, they say we talk too much. When we don't organize press conference, they say we are conniving with Mr. Ofori-Atta. How on earth could we have even connived with Mr. Ofori-Atta? Someone we had put on red notice. Someone we are the agency that has been investigating and going after him. So if you say we could have done a press conference, that is your view. But the SP would have evaluated all these things at the time. Remember, it was the transition period. That's when he left. And he had given prior notice to almost everybody on a medical ground. Now, OSP had its own intelligence that Mr. Ofori-Atta is not likely to return to the jurisdiction. However, the processes for triggering all these things was not just a one-day thing that you could have done. Just as people make it seem as if it's a very simple thing, just organize a press conference and people go to the airport and stop the plane at the tarmac and then remove Mr. Ofori-Atta from it. As you said, these are all security matters. He has gotten clearance from the highest office of the land. And the SP was making a point that he had not enjoyed cooperation from all the agencies that are supposed to support us. We're in OSP where security officers can be withdrawn at random. You are there, officers are saluting the office and saying, we have been asked to return to base and all that. We have gone through a lot. And what the SP was trying to say, that he was not enjoying cooperation, that even if he wanted to write to say the immigration boss, that they would have stopped him. It doesn't mean that the SP was saying that he had even written to say the immigration boss. He had said that the person had clearance to travel from the highest land. And even if you were going to go to court, you're going to go to court on your assumption that he will not return. When the person has a medical excuse, has booked a hospital and all that. So people should understand the situation. It was a transition period.
Okay.
And even if you want to hang it around the neck of the SP that he has made a cut or whatever boat.
No, the point is that you have the powers of police. You could have effected an arrest. You don't need anybody's permission.
Yes, you have the powers of the police, but you just don't effect an arrest. We don't just arrest people.
Yeah, why?
We arrest
why?
people.
You are like police, go to the airport and pick him up.
No, we arrest people when we have sufficient evidence of a crime. Remember, the people have so soon forgotten. They think that when the petition was made to us, it was so clear on the face of the petition that Mr. Ofori-Atta was the alter ego of the whole SML scheme. It had to take diligent investigation to bring out Mr. Ofori-Atta as the ringleader.
Okay.
It was not just on the face of the
All right,
record.
Sammy.
And I have one example I want to give. I beg you. Just one last thought.
I'm coming to you.
Just one last thought to go. People have said that whatever has bolted, Ghanaians, it's not true. See, what the OSP has done, we have saved the nation. SML was going to be paid $2.6 billion in 5 years. We have saved the nation that amount. So that is enough money that OSP has saved. Yeah, $2.7 billion US dollars. We have stopped that now. What they have already been paid is 1.4 billion Ghana cedis. And this 1.4 billion Ghana cedis, the OSP is in court to recover that in the event they are found guilty.
Vicky suggests that it may be late because properties you would have frozen and all of that may have been concealed.
I don't even know why people talk about these things as if the men and women who are working day and night. OSP has Asset Recovery Management Division. We just don't do investigation. As we do investigation, we trace assets.
So you have traced assets in this matter?
Of course, we have traced assets. There's no case the OSP investigates without tracing assets. If you talk about MPA, if you even talk about MEF, which is our next case we're going to bring about, we have taken so much asset running into millions of Ghana cedis. But these are not matters we always disclose. That's why I've said that the law gives us the leverage to be able to carry Ghanaians along. We are doing it
so when
should
Ghanaians expect that the summons will be served on Ofori-Atta? When?
I cannot give a timeline because these are court processes. Let's allow the court to set the dates. Let's allow the motion to be moved. And as you are aware, when we move the motion and it's successful and is served on him, if he does not return to the jurisdiction to face trial, the judge and the Act 30 will commit him to prison. And after he has committed him to prison, then the judge will issue an arrest warrant, which again brings us back to extradition. And let me give you an example. Although Sedinam Tamaklu was convicted under Godfrey, he applied for extradition, and up to today, the US has not responded to them. Is that incompetence? Why do we treat the OSP as if? But sometimes I understand because the OSP stands in a certain critical moment where it is doing so many cases.
Okay. Thank
where
you.
So many assets have been
Hassan says
seized.
he has a question for you. Please do it quickly. I need to take a break and then focus the discussion in the
Sammy, thank you very much. I have a few questions. I asked them before you came in.
A few questions.
Was the OSP investigating Ken on SML on any matter at the time that Ken was leaving the jurisdiction?
He answered that.
If he was, and you said that you have sought cooperation of other agencies, for instance, is there any evidence?
He has answered that.
No, because you see,
you are asking questions.
We write to the courts.
I want us to deal with
you understand? And then thirdly, if now you are seeking cooperation from the United States, for instance, there was ample opportunity for you to have activated, Mutual Legal Assistance Act 2010, Act 827, to have taken advantage to get video link to communicate with Ken Ofori-Atta, and he was willing to do so. Why are you now doing that now?
Let me give you let me explain this one.
He's answering
I'll
you.
give you that. I'll answer you that one. You see, this whole idea that we should talk to Ken Ofori-Atta, we don't get it. Have you noticed that we have done our investigation and concluded without Mr. Ofori-Atta because he can come to our office and say to us that he will not say anything. So as investigators, we are aware. But we needed Ken Ofori-Atta physically here to go through the arresting procedure where we can finally place him before court. Because remember, we have never trusted Mr. Ofori-Atta's excuses. And when we started, many of you told us that we were inconsiderate. And now we have been proven right. And we were thinking that Ghanaians would rather say that the OSP was right after all, that Mr. Ofori-Atta was unwilling to return to the jurisdiction unless forced to come down to Ghana. So please, sometimes you should understand that the OSP is very professional. We know our work. We know what we are doing. We are the only state agency on record that is investigating Mr. Ofori-Atta that has at least made a lot of steps and efforts. And the fact that we do something and sometimes we are not successful does not mean that we are incompetent. The fact that people run narratives for their own parochial interests and also for the interests of the people we are investigating does not mean that the OSP is not functional.
Sammy, thank you very much. Thanks for your time. We need to try and wrap up, and then I'll take a quick break. So yes, Hassan, can we focus the discussion on what is happening in court now, or you want to talk about whether or not the tactics, inactions, and so on, therefore the OSP should be removed?
I'm not, one of the persons who think that somebody should be removed from office by reason of the fact that he hasn't done what I personally think he should do. There is a standard, all right? And so we should judge the special prosecutor based on certain objective standards. And I don't think that I can stand here and say that the special prosecutor is not doing his job well or not. I mean, the jury is out there. But because Ken Ofori-Atta and
the jury is out there, it's you people who are feeding the public out there. And depending on what you say to judge the OSP.
Ken Ofori-Atta first accused and Sakori second accused. It appears that without the two of them, this trial will not happen. And I think that is completely misplaced, assumption. And it would appear that the 6 other persons are more or less canon folders or dispensables.
The 6 others
expendables. I mean, people are just adding them. The real target is Ken and Ernest Okori, and these ones have just been added to. Otherwise, if there is a belief that they have equally committed offenses which are germane to the investigation, then the prosecution can continue.
Okay.
Without necessarily having Ken Ofori-Atta.
All right. All right. Any quick comment before I take a break? Yes, Dr. Atta Kennedy, any quick comments?
Yes. I think, though, that the Office of Special Prosecutor could still have arrested Mr. Ken Ofori-Atta and then asked that his travel be prevented by a court after the arrest. I know that they arrested Professor Frimpong-Boateng very quickly before they released him on bail, so they could have done the same
Professor
thing.
Frimpong-Boateng had attended to their office. Then they placed him on arrest.
That's my point.
Yeah.
That's my point, that they have arrest powers. You just made my point, that they could have done that and then gone to court to say that they could release him on bail, but his travel documents could be seized. So they had options. I also think that it will seem that despite the explanations, the Office of OSP does not seem to take on board the fact that maybe things could have been done a little differently. I'm sure they are working hard, but it will be helpful to be humble. But of all this, we haven't put on the table the fact that I think the public has risen to be skeptical because the OSP during the early part of his tenure had a more cordial relationship with the Nana Akufo-Addo government. And I think that changed. There was a time when it seemed to be working in tandem with the government, had a very good relation with the Attorney General. And I think that changed. So that has also affected the perception. But I think, though, that this is not a lost cause. Sounds like they are doing some work, and I think that even if Mr. Ofori-Atta is convicted and doesn't come to Ghana to serve any term, the opprobrium should serve as a warning to others, and I am sure that he will feel embarrassment. So the case should go on, but I think that for the office of the OSP to say this is going on at record pace indicts the whole system. Justice delayed is justice denied. These things should be speeded up so that innocent people should be cleared so they can go on with their lives.
Thank you.
And the guilty should be punished.
Thank you. Theophilus.
Yes,
justice delayed is justice denied. Justice hurried is justice buried.
Yes, I agree, but I think that it appears from what Sami has said that a lot is being done. I can't understand why they didn't take the offer to interview the OSP, the Ken Ofori-Atta by video means. That would have satisfied the Electronic Communication of Transactions Act, and that would have been that he's put on notice that there's an investigation ongoing. But I am gladdened that they are issuing a criminal summons and to get the charge sheet served on him.
Did you think that they will not issue it?
No.
Did you think that after filing the charges, they won't issue the summons?
No, my worry is whether it should have been done before filing the charges. Or
could it be done before filing charges?
There could be. If you read the act, it says that if you have reasonable cause, you could even approach the magistrate and do oral presentation. So that one, you don't need charge sheets. So if that is it, so they could have done that and would have gone this way. But perhaps they have looked at the situation that if they had gone that way.
So let's educate the people.
Yeah.
You know, earlier they had gone for something of the sort.
Like
an arrest warrant,
yeah,
which they were using against him.
Yeah.
If you say that ahead of filing the charges, where the person is not around, they could have gone for a summons. What sort of summons would that be? The summons is to serve the charges.
Yes,
if they haven't filed charges, how could they go and get a summons?
No, the Act 30 didn't say that file charges before.
No, I'm talking about now. Where they got to was that they needed a summons to serve the charges.
Yes.
So if you don't file the charges, how do you serve it?
No,
how do you go and
I said this earlier.
Okay.
That summons could be served by leaving the charges at the last.
By leaving the charges.
Yes, the charge sheet at the last place.
But you are saying they could have gone before they go for the charge sheet.
No, so you could have left it at the last known place, or before for somebody above 18 years. Or could have posted it on the doorstep. So now that they are going for that, yes, we agree that it is not completely a lost cause. But my worry has only been the 78 counts. However, with the Sedina case, I think that we have a history. So perhaps they will be able to rope him.
Yes, quick comment, Vicky.
Yes, I mean, I also agree that it's not a lost cause. I guess, and I'm happy to hear all the work that they've been doing. Nobody's suggesting that the OSP is not working hard. We're just saying that, you know, maybe certain things could have been done in a different way. I just have two questions in my mind. Now that, because the red notice, at least when that was in place, they knew where he was. Now that it's been redacted, he's free to move anywhere. So I'm not too sure how they're going to serve him. But then they are the investigators, so they'll have to locate him. But the world is a big place, so that's one challenge that may possibly.
Okay.
And then the question of assets, yes, they've traced the assets, but it doesn't mean that, you know, there's no hold on the assets. So tracing them is great, but if you're not holding them, you may go back and update your list and find out that some of them are.
No, once it is traced, you can't conceal.
Okay.
Yeah, you can't conceal. If the process is against you, the process is against you at the time you are concealing it, it won't work.
Yes.
Yeah.
Yeah.
All right. But yes. Hold on. One question to you. Do you know of any precedent of a trial in absentia in Ghanaian law where the person was not put in a court before the trial continued in their absence? Do you know of any? If you mention Sedina, if you mention Benjilo, all of them, they had been charged physically in the offices of the prosecutors and then taken to court, and then they bolted.
I am thinking
then the trial went on.
I'm thinking about something I think happened under the PND. I think a former IGP. There was a case like that. Before we close, the name might come.
There's a difference in describing the suspect as being at large, right?
Yeah.
Okay. Quickly.
Samson, I
raised that because for many lawyers, when they are talking about, trying absentia should have been the first thing to do once you don't find him, you will come to realize that we are going to face
that's what
a problem.
That's what I said from the beginning.
We're going to face a problem with that.
That's what I said from the beginning. They will struggle to get that.
I've taken note of something very significant that is happening during this trial. And it's the fact that mugshots of the accused persons were taken. And the purpose for taking those mugshots, as enshrined in law, is to be able to identify them and let the whole world know in the event that they abscond. Now, in this instance, the people are standing trial. They have cooperated with the investigators. So I don't know what their mugshots are doing in the public.
Okay, thank you.
So it's a presumption of guilt. And you know, when you do that, you shame the people, you embarrass them. So what if they go through this trial and then they are cleared, acquitted, and discharged? What happens?
All right,
thank you. So please.
Thank you for raising that point. Thank you for raising that point.
Some of these things.
When Trump's mugshots were taken, he himself decided to put it up and display it in the Oval Office. We'll be right back after this break. You're welcome back. This is Newsfile. It's your most authoritative news analysis platform, and here on Newsfile, we put Ghana first. Let me share some of your messages. Then we proceed with the next installment of the matters we are discussing for you, and that's about bail. So related, whether the EOCO is just being, lawless in the amounts of bail that it is giving. Okay. This one says that your plaintiff sigh when you uttered the phrase, this country, quote unquote, this country was not lost on me. I felt the same way too about the legal and justice machinery at work in this country. I also wonder, like the lady lawyer, whether things will change. Dr. Atta Kennedy spoke incisively and insightfully about the issue, but I wonder what will change. Great programming. I'm following with rapt attention. Thank you very much. And then, those of you commenting on Samson's stake, I'm not reading about Samson's stake. This one, Mr. Edu says that until we are ready to hold our presidents accountable, we can't fight corruption. Are we trying to say ex-president Akufo-Addo had no idea of the gargantuan corruption that happened under him? In any serious country, the buck stops with the president. The person who needs to be interrogated by the investigation agencies is the president, as in Akufo-Addo. The immunity clause should be reviewed now, or else forget about fighting corruption. Imagine an ex-president who has run the country bankrupt and enjoys full motorcades, full security, and all other full benefits of the state. This is a huge joke. We are not a serious country fighting corruption. Okay, maybe we should go and learn from Brazil and other places. They put ex-presidents in jail. Question for Sami. In April, the special prosecutor told us that the reason why Ken needs to attend their office in person is because their investigations have yielded enough evidence for him to be charged. How come it still took them 7 months to charge him? Okay, that's from Kojo. Albert says that a number of issues he raises, but I can read only a couple. He says, if he has nothing to hide, one of the panelists made the point. We are dealing with white-collar criminals who are very smart. Now the charges have been filed. His lawyers were shouting he had not been charged. Frank Davis, right? Now he has been charged. They should produce him, get him bail, and let him face trial. You cannot put impediments in the way of the OSP and accuse the OSP. They should produce Ken now. Double standards, all trickery and needless technical effusions from those blaming the OSP now. He has been charged. He has constructive notice. He should come. He should come. It's as simple as that. Let's not simplify what challenges the OSP is facing. On hindsight, it is easy to criticize the OSP. Don't forget, the man had lawyers who were making the OSP work difficult. Ofori-Atta should just come and face trial. I read a couple more of your messages. Manche Bruce says the OSP appears to be undertaking a political witch hunt rather than objective prosecution. His handling of almost all the cases before him has been nothing short of a malicious prosecution and a florid pursuit of fantasy. Hey, for the OSP, you are guilty until proven innocent. His modus operandi have been to be playing on the emotional keyboards of the public. His flagrant abuse of the mugshots of accused persons is unfair. How does he expect to pull through with 78 counts against Ofori-Atta and others? Amazing conviction. Manche Bruce. Takrade. Thank you, Manche Bruce. Papa Bisu. Papa Bisu always says what? Sphincters Road or Sphincters. Says, I believe it is high time we found some ways and means in bringing down Ken Ofori-Atta. Sad to say, with him out there, huge sums of alleged looted state monies via him and his cronies at Setting Island and other countries, seriously speaking, some covering up by him, will lead to Ghana becoming a bigger loser relative to hardship and sorrow he brought on us via his role as a former finance minister. Okay, thanks for your message. Yakubu Ibn Chambers says that, oh, your long message is so, do you know why the thievery and rot in the Ghanaian system continues to fester like a virus attack on the human immune system? It is because the perpetrators of these unforgivable financial malfeasance know in their hearts that they will enjoy the best legal brains to thwart any prosecution in the future. I suggest this country adopts the realist approach to prosecuting wrongdoing, where the law is put aside and real-time evidence is applied to prosecute. The delayed tactics in financial recovery and prosecutions are nauseatingly painstaking. Yakubu Ibn Chambers sends that from Wale Wale. And the final one says, I laugh when Mr. Atta Kennedy said that, Dr. Atta Kennedy said that wouldn't have done anything to this Ken's causes, looking at what he went through at Honorable Ken's hands. Ask when Dr. Baumia was in charge of the economy, what happened? And when they sabotaged Dr. Baumia, what were the results? Gamel. Okay, I don't really get your message, but that's fine. Thank you very much. Now, let's move on to the next issue about bail and EOCO. It appears that they are being accused. Okay, so accused. All of them are being accused. So let's listen to the EOCO boss, Raymond Archer, former investigative journalist, on whether or not their bail is intended to keep people in jail.
I think some of the lawyers think that we have disrupted the bail system. And I will explain my philosophy to you. And it's very simple. I consider bail and sureties, or I liken it to the collateral you give for a loan. When you give a collateral that is less than the loan you take, there's no motivation to pay back. You can let the loan go run its length, and then there's no collateral to fall back, and you go into default. In the same way, bail is connected to a case. So imagine if I have a case of 100 million, the exposure or the risk. We do a lot of investigation for the banks, for example, where somebody has stolen $90 million. And then you catch the suspect, then you give him a bail of $20 million. Now, like I told you, assume at every point that every criminal is at least above average intelligence. The fact that he beat the banking compliance and everybody to steal that money tells you he's not your average Joe.
So, as you know, some of the people who have been charged for millions of financial, mismanagement or corruption. For example, Kwabena Edu-Buahing in the National Signals Bureau's case, he was a former boss. The bail sum giving him was 80 million with two sureties. Alhaji Abdul Wahab of the NAFCO, 50 million. Bernard Enchibu-Esiako, the chairman, Wuntumi, 50 million. You had Charles Mensah, is in Niyama, Chatawale, he had 5 million, two sureties. Almost all the cases, they are looking for two sureties. Edwin Provençal, former boss, he 30 million, two sureties. And then you had the NSS, heads who were also arrested. And the courts are now reducing the bail sums for those who were not able to fulfill them. Some spent 2 weeks in jail, in custody, some spent less, because it's difficult to come up with the fulfilling the conditions. Yes, Hassan, why are you guys, even in Parliament, you are raising this issue that bail is being used as punishment?
Yes, I think that this matter again has been discussed on this same platform before. And the overwhelming view is that it appears that bail is now more or less being weaponized, being used as a weapon to oppress, suspects or persons of interest, with some very onerous bail terms and conditions. And I think that there has to be some kind of, realignment and regulated environment as far as bail is concerned. It has never been like this before until just recently. And if you have observed, there are different agencies handling this kind of cases. You have the OSP, you have the EOCO, you have the NIB, and I think the CID as well. Most of the furore and indignation is directed at mostly EOCO. OSP, you will hardly find any instance where OSP will insist that somebody must be held in custody. And not many people have gone to OSP, except maybe one or two that you hear about them in the public, especially with the exception of maybe Paul Adumochi because of who he is. And even that one, the bail conditions were not such onerous bail conditions. Now, what happened to self-recognizance bail? We're in this country for the 8 years that MPP was in power. Can you mention one person who was held in custody because he couldn't meet any bail conditions? Can you mention one?
You may not know.
You see, we have had Stephen Opuni, Seydou Agongo, Dr. Kwabena Dufour Jr., they have various chief directors, they have business persons. They were all released on bail right from the beginning. Second, you have another group, Dr. Tuforsin, Dr. Kwabena Dufour Sr. himself, Alhaji Collins Dauda, Kweku Ajima-Mensah, and all of that. They were granted self-recognizance bail. Then you have another category.
By police or by court?
By the court.
So we're talking about the police bail first.
Even at that level.
We're not talking about court bail.
Even at that level. You will never hear it. Richard Jakpa, for instance, was he ever detained? He never slept in custody for 1 day.
Do you know that for sure?
I am telling you for a fact. So all these things about, we need to tie bail to the sums that, apparently had been lost and so on and so forth. But there are people who have been held in custody unrelated to any loss of money. So why are you still holding them in custody? What are you trying to recover from them? In the particular case of EOCO, if you go to their functions, Section 3, it provides that that the EOCO would recover proceeds of crime, for instance. So in the mind of the executive director, if from their investigation, you are deemed to have caused or misappropriated 60 million cedis, then he has to give you bail conditions amounting to about 60 or so million cedis. That is wrong. And I think that the application of bail should be regulated under Article 296 of the Constitution because it's an exercise of discretion.
What Raymond said? He said his philosophy. What's wrong with that?
Yeah, he said his philosophy. Now, there are people who have occupied that office before him.
Is that philosophy compliant with the law?
It is not.
Why?
It is not. Look, we should be guided by the provisions of Section 96, for instance.
Yes, what does Section 96 say?
It provides...
What does Section 96 say should be how to deal with bail?
I mean, it talks about bail not being excessive. That one is very clear. And if you have it, we can read Section 96 copiously for the benefit of the listeners. You see, bail is being used as a weapon to oppress even accused person. Look, if you have a very solid case,
the law says you grant the bail depending on the circumstances of the case, but you shouldn't use the bail as punishment. It shouldn't be excessive.
That is what we are seeing.
Who determines that it is excessive or it is being...
At the point of inquiry, it is the agency that is doing the investigation that must exercise that discretion.
Right.
And it's a discretion that must be exercised, that they must exercise with, a lot of, empathy. But it appears that the whole idea is to convict you even before. We want to hold you in custody even before the trial starts. That is the whole intention. And I think that it is very wrong. Look, it has to be regulated by Article 296. But when you are exercising discretion, it must not be capricious, it must not be whimsical, and so on and so forth. But that is what we are seeing. Because the ED, for instance, when you heard, he said that his philosophy, so that makes it, capricious. And because people have occupied that office before, and we haven't seen some of these things before. It's the same law that we are applying, it's just different individuals. So he brings different philosophy to the office, and I think that it has to be regulated. It is, look, BNI, for instance, has investigated a whole lot of people. You will hardly hear anybody, maybe because he's a media person, coming from the media stock, because almost every case of EOCO is in the media space, especially if it has to do with any politically exposed person. So we have to be, as a country, watch it the way that we do. Otherwise, one day somebody will need Kotoka International Airport as surety. You need a property, maybe Tema Harbor. Because the rate at which we are going, 800 million, 150 million, 100 million. I mean, how many people have that kind of properties? You say for to be justified. So that means that one person amongst them should be able to bring not less than 25 million. I mean, why are they going to get these kind of properties? They are not realistic. So we must be measured, in the kind of bail conditions that... Look, for instance, if you look at Bost, Edwin Provençal, he was given a bail terms of 60 million Ghana cedis. The court reduces to 30 million. EOCO is appealing. What are you appealing for? What is it you're appealing for? And then, to make the matters worse, when the court varied the bail conditions, EOCO continued to hold him in custody pending appeal. That is wrong. That is completely wrong. You release the person.
They had met the bail conditions.
They gave it 30 million cedis, and they satisfied the bail conditions.
And they were still holding him.
And they held him because they are appealing.
Are you sure about that?
The individual's rights.
Are you sure about what you just said?
Of course, that is what I have been told.
Okay, so
that's what I've been told.
So
and his lawyer is one Charles
those who are involved in this case, and
so
maybe
please.
EOCO officials, if you are listening, we want to know. We want to check this.
Yes, I stand corrected.
We cannot immediately, independently verify what he's saying. That even after the court granted, varied the bail terms from 60 to 30 million.
That is what I read.
He fulfilled the conditions. He was still kept in custody because EOCO was appealing the decision. We would like to know about that.
Yes, so I stand
in custody. He's not in custody now.
Now I don't know.
So, but EOCO is still appealing.
Yes, I don't know whether he's still in custody.
No, he's not.
That's what I'm saying. I'm not aware. But I read okay, that he has met the bail condition.
My question is that if he was being held because they were going to appeal,
yes,
then because there is an appeal, the appeal has not been determined, so he should still be in custody.
That's what I'm saying. I don't know whether he's still in custody or not. But the point I'm making is that, and I've been involved in arranging bail for some.
How much is involved in his case?
In his case, I think it's about $5 million.
So how do you describe 60 million Ghana cedis as excessive or punishment for a case of about $5 million?
You see, you are presuming that the person is already guilty. That is the wrong thing I'm saying. You are based on Article 19, 3C or so. Correct me if I'm wrong. A person is presumed innocent until he is proven guilty or he himself admits to his guilt. But you are assuming that once you have been accused of embezzling $5 million, then you have stolen that money. And the only reason why
Theophilus is holding Act 30.
The only reason why we will grant you bail.
We had invited you earlier to read.
The only reason
96.
why.
Hold on.
Yes.
Section 96.
I have Section 96.
Please read to our hearing.
So,
a court shall not, and it is
which part of
mutatis
96?
mutandis
Which part of
applicable
96?
to Section 96. 5.
4
rather. Yes. A court shall not withhold or withdraw bail merely as a punishment. And 5. A court shall refuse to grant bail if it is satisfied that the defendant may not appear to stand trial. That is 1. Or 2. May interfere with a witness or the evidence or in any way hamper police investigations. C. May commit a further offense when on bail. D. Is charged with an offense punishable by imprisonment exceeding 6 months, which is alleged to have been committed while the defendant was on bail. None of these conditions.
But why did you? This is not conditions. This is the refusal part.
This is the refusal, and I'm saying that
you jumped how to measure the bail.
Oh, but I think I've read it.
You jumped. You stopped. You started from shall not. How is bail determined?
The amount and this is C. This is 96.3. The amount and conditions of bail shall be fixed with due regard to the circumstances of the case and shall not be excessive or harsh.
So that's the question.
With due regard to the circumstances of the case.
Thank you.
What does that mean? Does it mean that the
gravity of the case?
Exactly.
So if you are facing a charge of $5 million US dollars, translates into how much in Ghana cedis?
That's almost about 60 million cedis.
And you are asked to post a bail of 60 million Ghana cedis.
Yes.
How do you say that's excessive?
I'm saying that if you use the amounts to determine the bail, then you are more or less convicting the person.
But that's what the courts do.
No, the courts don't normally do. Why do they?
They do.
Okay, so why do they give self-recognizance?
Ask any judge. They will tell you that they use.
So what is the criteria for
the gravity of the offense?
This same law.
Determine the bail.
This same law provides for self-recognizance in spite of this.
It's discretionary.
So it's discretionary. That's what I'm saying. So you can't say that because the amount is this, the bill should be necessarily tied to the amount. Then why do we give this in the self-recognizance bill?
In the NSS case.
What is the intention?
In the NSS case, we are talking about 2.2 billion, right?
Correct.
And they are granting bail to the tune of how much?
800 million and even 10 million.
Yes, 10 million.
For Gift Awari is 10 million.
Yeah.
And for the OCICB,
for a case
800
of
million.
2.2 billion.
You understand? No, but they are charged for different,
I get that.
Amounts.
How do you determine excessiveness?
Precisely.
When you use the amount. That's what Raymond is asking.
No, I'm saying, for instance, let's use Gift Awari's case, for instance. How much is he shared to have embezzled? 30 million or is it 40 million? But the bail condition is 10 million. Now, OCICB is said to have embezzled about 1.2 billion Ghana cedis, but the bail condition is 800 million. So why would the court, for instance, reduce the bail terms from 60 million to 30 million for Edwin Provincial?
Because it is not necessarily time. It is about whether the person would appear.
Do you agree?
To stand trial.
Theophilus, do you agree?
No,
More importantly.
I don't agree. There is one part of the, in fact, he jumped nicely in the 96.2, which says that where a police officer or a district court has given a bail condition, a circuit court or a high court can reduce it. And that they could have done easily. I don't see where he's taking this from. What Raymond Acha said is, assuming the issue you are contending with is $5 million, as you said, and you give somebody the bail sum of 5 million Ghana cedis or 10 million Ghana cedis, and the person decides that, yeah, I'm really guilty, let me abscond, and my surety, they can pay the 10 million and I keep whatever million I have. That is some of the things that go into grant of bail. Senior, as you said, we have had this discussion before. If a police officer, EOCO, or whichever body has given bail, and you feel that it's excessive or onerous as it is, you apply to the court, the high court, as they've done in Provençal's case, to get it reduced. Even when the court themselves give bail and you feel that it's excessive, you sometimes apply to the court to get it reduced. The idea that it's excessive, we cannot really say, except they tell you that we are going to use the bail as punishment to hold you. They don't. And again, let's educate our people. I am getting the impression you mean that when they ask you to bail condition of 50 million, it is like you have to pay the 50 million. No, you are not to pay the 50 million. So asking whether...
That is the philosophy behind
No, that is not. You are not supposed to pay 50 million. Is the situation where the sureties will guarantee that they will bring you to court. The whole purpose of bail is to bring somebody to court, to appear before court.
No, but the sureties.
Yes, the sureties.
They are supposed to show property worth.
Yes.
Worth the amount.
Sina, I don't know whether you've heard that when a certain judge, she's now in the Court of Appeal, she says unless she specifies the type of surety, she's not asking even for landed property. So you could go on to challenge or ask whether they really needed landed property in terms of the sureties. It could be to guarantee just by posting affidavit of surety to show that you are ready to, when the person absconds or is not ready to appear before court.
Know that.
Yes.
Once the decision is that the surety is to be justified,
yes,
then you really will need the property worth that value.
Yes. Senior,
and this is the circumstance you are fighting.
Senior, you see,
and he's telling you that to the extent that the court is looking at it with a different view, you give 60 million and the court casts it to 30 million, it shows that you are being excessive.
No. Senior, the courts themselves can give 60 and you go back to the same judge. Look at the Asibe case. They went back to the judge and the judge reduced it. It doesn't mean that the judge himself realized that what they have given is excessive. If the judge realizes that they are excessive, they reduce it. It doesn't mean it is somebody who has influenced the judge or using it as punishment. It is that you look at the circumstances. You go back. We do it always. Bail conditions are given even by the court. You go back to say, even that day, you tell my lord, my lady, that looking at the circumstances, my lady, this particular type of bail is as if you have refused the bail. Our application for bail. So, my lady, kindly reduce it or look into it and give us something that we can be able to
He's saying that some of these people, almost all of these people, please hold on, almost all of these people, they are public figures. All right? Why don't you exercise the discretion to grant them self-recognizance, where they only come and then they show you their ID card, and that's enough. Then you let them go. Or perhaps even just, detain their passports.
Yes, Samson, you use the word discretionary. The person who exercises that discretion would have had the privilege of having certain information that yourself, myself, don't have. That is in the wisdom of that person and using that discretion. This is what I will give to make sure that you appear before us or you appear before a court of competent jurisdiction the next time you are asked to come. We have had a situation we just discussed this morning where people have absconded. So there is history. At least certain things inordinately or inarticulately would have been at the mind of somebody exercising discretion. It is not, Senior, the idea that is excessive is neither here nor there. If it is excessive, we have had this discussion before. Go to court, ask the court that it is excessive. The court will reduce it. You don't lose anything. The only other thing you lose may be your application and your advocacy. So for me, I don't see this to be a big issue that the one that worries me is to ask the AG why the courts are even giving those type of terms. The AG does not control the courts. The courts have their independent minds and their independent way
Is
of...
the AG who applies...
No,
The Supreme Court has said...
Is the AG...
The Supreme Court has said that bail is not ministerial.
Yes.
It is judicial.
Yes.
So if police inquiry bail, as EOCO, OSP, and Co are doing, they give you bail and you're not able to meet the terms, within 48 hours, are they not supposed to take you to a court for a court to determine your bail because you are not free? The law says you have to be released
within 48.
either unconditionally or on a condition.
See now, if you go to section 15 of Act 30, it says that the bond may be enforced as if it were a bond executed by order of court. So if the police or EOCO gives you bail with those conditions and you are not able to meet it, it is as if the court has given you those conditions and the same way they will enforce it. So it is not a matter of they've given you bail, you've not met it, so within 48 hours or after 48 hours, take you to court. Please. It's in section 3 here as well.
Section 3 says what?
Read says that a person referred to in, that is custody of person restricted, may at any time before or after the expiration of the period of 30 days be required to enter bond with or without sureties for a reasonable amount to appear before the court or at the police station or place and at the time as stated in the bond. The bond may be enforced as if it were a bond executed by order of a court and condition for the appearance of that person before a court. It is section 15 that the police, the EOCO, etc., have that authority to grant bail or not. And the section 15.3 says that that bail that they will give you, it is as if the court has granted you bail. You cannot say, senior, if you appear before court and the court grants you bail and you are not able to meet the bail conditions, because of that, they should release you or they should take you back to court within 48 hours again. If that is the situation, that cannot be. Okay. So the idea that you have been granted bail in EOCO or police and you have not been able to meet it, senior, it just means that we have released you. Meet these conditions and go home. You've not been able to meet them. If you feel that our conditions at police station, EOCO, NIB are too much, go to the court, as he said in 96.2, to say that the conditions are excessive. Please look into it as it's done in Professor Aske.
Okay. Dr. Kennedy, what are your thoughts on this about the bail? And it's notoriously known when people are public figures, when people are MPs or they have been MPs before, they have served the Republic before, that it is easy to grant them self-recognizance where they are not required to give anything. They are not required to bring sureties, because we can trust. Some of the people involved, they have property, they have family in this country. The suggestion is that you cannot be saying they will want to run away from Ghana, you know? But some people will say, well, what do you say about Ken Ofori-Atta? Yes, that is if he has run away.
It's a complicated case, and there are good arguments on both sides. Let me begin by saying that in 1984, when I was arrested and charged with subversion by the PNDC, I was granted a self-recognizance bail, because if I had to meet bail conditions, I probably would still be in jail now.
And the PNDC, as a student leader, you were granted self-recognizance?
Yes, and I had to report every day to the police for 1 year, every morning. So I don't know why they can't do the self-recognizance bill. But having said that, looking at Ken Ofori-Atta and Sedinam and others, I think that the authorities have reason to worry that there are people who, if granted bail and the conditions are not stiff enough, may abscond. There are other things like maybe house arrest, wearing a monitor and all those things that must be taken into account, but
we don't have those in Ghana. We don't have those in Ghana.
Well, it is technology. I mean, maybe we should talk to Dr. Baumia.
Okay.
I think though that.
By the way, do you support him?
We should worry about the exercise of discretion, because, for example, if we have the head of EOCO say, "In my mind, this is how bail conditions should be. And then you go and a judge has a different perspective. I realized that during his confirmation hearing, for example, Chief Justice Bafuboni, congratulations, said something about the sentencing of Atai, which showed the exercise of discretion that should trouble all of us. I think that discretion in the granting of bail and others should be attended by clear guidelines that will limit the abuse of the discretion, if even innocently. I believe that when you look at our Constitution and you look at something like Martin Peby versus Attorney General, and then you go to US and look at cases like US versus Salermo and then Stark versus Boyle, it is very clear that the purpose of bail is not punitive. It should just ensure that the person will show up in court, and we should be careful about a situation where it drifts to have punitive implications, because when we do that, then we are drifting away from the anchors laid down by the Constitution. So I think we should look at that. But Samson, while we are talking about this, I think we are really focusing on the problems of big men. I know you do a lot of very admirable work in the prisons. There are a lot of anonymous people who rot away in jail when, in effect, they should be out because they have nobody. You know, we just put them on remand. They don't have lawyers. They don't have anything. And sometimes 3, 4, 5 years later, you go and they are still sitting in jail. I think that maybe we should broaden this discussion because their liberty should matter just as much as those of the big men too.
That's right. That's right. Okay.
Samson.
Yes, Vicky.
EOCO has done something I need to put on record. So we say that normally their bail terms are excessive. There is one particular instance where their bail conditions were much lower than the bail conditions of the court. I need to put that on record. And that is in the case of Republic versus Abdul Hanan and the wife. EOCO gave 50 million for him and then 30 million for the wife. But the court gave 100 million for Hanan and 50 million for the wife. So this is just one instance where I've seen that discretion has been much lower, but on almost every occasion. And I think I have to commend them. Maybe they did it because some interventions were made, and they probably saw a member of the Constitutional Legal.
So they gave 50, and the court increased it to 100.
200. You understand? And this is based on the facts of the case, because post-investigation, the facts probably, have, led to a lot.
Thank you, but I really need a confirmation that Provincial has met his bail conditions, and yet he's within EOCO cells, because I think by Wednesday, by Wednesday we knew that he has still not been released by Wednesday, so we need to know what is happening, and the party people had. Gone there demonstrating that he should be released. We should know. If he has met his bail conditions, I doubt. How does that work? That he's met his bail conditions and he's still being kept there. I doubt that will work. Yes, Vicky, so what do you say?
Let's get answers to those.
Excessive bail conditions?
Yeah, I think, all the arguments have been advanced, so I'm not going to say much on it. The most important thing is that EOCO has a job to do. We all support EOCO in exercising its mandate, but they have to do that within the rule of law and within the confines of the Constitution while respecting people's human rights. I think that's the fundamental point. So bail should not really feel like it's a punishment before trial. And that's what we're all kind of kicking up against. And for me, the bigger danger really is if we continue in a certain direction, and I'm not suggesting they are or anybody is, but if we do continue in a certain direction, it could set a bad precedent, and if that happens, then human rights violations can become normalized without we even realizing that that is the
idea of the bail in these cases is that there is no incentive for you to run away.
To run, yes. And I know that the main purpose of bail is to make sure you show up.
Correct.
So if you think about it in that terms, yes. But it's not, I don't think it should be as narrow as that. You know, because in every situation where you have the Constitution, and that's in every situation, and then you have human rights, you have to do a balance. And I'm not suggesting that EOCO is not striking that balance, because the sums involved are staggering. And these are huge amounts of money. So if he's invested, say this 1.4 billion, for example, and then bail is set as 100 million, people will be like, why? You know, so it's just getting that balance between mandate, constitution, and human rights.
So, you know, experience tells you a different story. Truth is, if any of these were my clients, I'll say, this is too much.
Yeah, so
but what I'll do will be to go to the next step and try to get a reduction. I've seen a situation where I have to represent people who stood surety for people. And because the sums were not much, one used his house, the other used his house, all to support a friend. He ran away.
Oh, so they lost the house?
Their properties were at stake.
To street the bond.
Yeah.
So this is somebody who felt, after all, my skin has not gone into the game. It's my friends who are using their property to help me out. So he could run away.
That's a moral challenge.
So he ran.
Wrong, yeah.
So he was traced to Nigeria, but it was difficult to get to him to bring him to the country. And so his friends rather suffered.
So it's always
I'm not discouraging you from posting bail shortly for your friends.
That's a
as much as you trust them. Thank you very much. This is Newsfile, it's your most authoritative news analysis platform. And lawyers and teachers, professors are sending messages to me that we should be careful we don't miseducate the public. I don't have his permission to mention his name. This a lawyer, professor, teacher. He says the gravity of the offense is a material fact. When a lawyer says it's a material fact, it's not common English. It's a material fact to be considered in determining bail. We should let the public know that. Then this other one, Albert, is also a lawyer and teaching. He says that judges use the amount involved to peg the bail is a fact. Let's not change the rules because that's what they are. Kojo says, let us be logical. Why do we peg the bail amount to the amount the suspect is accused of misappropriating? Should it not be tied to the known assets of the accused? They may be innocent and may not have misappropriated any money. So if you ask them to go and find access to the tune of the misappropriated amount, where are they supposed to go and find that money? Or is it only people with rich friends who deserve justice or bail? Well, I can assure you that judges always look at your circumstances. So if you are a poor person and you have committed these little offenses, we get bail for people. I mean, self-recognizance. They may not even be known, but the judges, sometimes they look at the circumstances and they'll believe and grant you bail to go. But when the stakes are this high, they are very careful. We'll be right back. You're welcome back. This is Newsfile, it's your most authoritative news analysis platform. And here on Newsfile, we put Ghana first. And I've Hassan Tampolo here, I have Vicky Bright here, Theophilos here, and also Dr. Arthur Kennedy is on the line. Now, you are very familiar with this situation where NIMOS is going around the country and they themselves are getting, into trouble. They are being beaten around the place and now they are dying. They don't appear to be as equipped as will be required. But now we're told that the president has told us that cabinet has approved a bill for public tribunals. And these tribunals are going to be dedicated to the Galamsey prosecutions. The question we're asking, the army in the forest, is it really a question about tribunals? What difference will that make? Theophilos, what's your understanding of what these tribunals will do to change anything, if at all?
Yes, my understanding is that we already have the tribunal system in our books or on our books, but their jurisdiction and what they are allowed to handle does not include the Galamsey situation we find ourselves in. And at the last meeting with the CSOs, the president's meeting with the CSOs, the Attorney General indicated that the bill or the tribunal system for the Galamsey thing will give definite time limit for trial of Galamsey cases. Maybe we should liken it to maybe fast-track courts of yesteryears. So they had a situation where they feel that the judicial system is already choked. People go to court today and they are back to the field tomorrow and continue to work, do the same thing, and they are arrested, they come back. So this should be specifically to handle Galamsey, and they should have a definite time span. Indeed, I think the Attorney General mentioned 6 months for the cases to be dealt with. Then after that, the persons on the panel are also aware that each case is supposed to be dealt with within 6 months. Either you dispose of it or the case cannot go on. So the idea is not necessarily to make extra courts, but the idea is to fast-track prosecution within the Galamsey field. That is basically what the new tribunal system will be. And mind you, it's already on our books. The Constitution makes provision for it. Act 59, the Courts Act, also makes provision for the tribunal system. We have the regional tribunals, we have circuit tribunals already on our books.
Right. I can confirm that one idea of the tribunals is that there are strict timelines. There's not going to be trials forever. And another effective part of it, Hassan, is that this interlocutory appeals, when the trial is going on, somebody raises one objection, the judge rules on the objection, one party is not happy about the ruling, they are going on appeal. So if in one day a trial is going on and somebody raises 6 objections and all those objections, they are overruled, there will be 6 different appeals perhaps, and that will stall the case. This is not going to allow for that. If you have any appeals to make, wait for the entire case to be over, and all points that you may have raised, you can appeal in one bulk. So this will help the Galamsey fight, won't it?
Samson.
Speedy trials.
I am surprised that at this moment in time in our democratic journey, we are bringing back the tribunal system to come and assist in disposing of cases with structures that are a bit different, not allowing interlocutory appeals and so on and so forth. Much as we are fighting the Galamsey menace, we should be mindful about the fundamental human rights and freedoms of our own people. Now, what we are doing amounts to what I call knee-jerk reaction. We know the solution to this Galamsey fight. It has nothing to do with the prosecution or otherwise of cases. It is just a way of bringing back the tribunal system because it's an electoral promise that the NDC made. The NDC said they were going to bring back the tribunal system. They didn't say they were going to bring it for the purposes of Galamsey.
The Constitution has not abolished tribunals.
The Constitution has not abolished tribunals, but over the years, I don't know when you last saw a tribunal sitting. Because it is one of the relics of the revolutionary period, and we wanted to do away with those things. We used to have the citizen vetting committees, we had the CDRs, PDRs, ACDRs, and so on and so forth. We want to forget about all of those and work with the regular course. So you can. Some
say tribunals are more effective. You have a judge who is the chair, and then you have 2 other people who are not lawyers. Who are not lawyers.
Yes.
We don't know how they'll be chosen now. Who are not lawyers.
Yes.
Maybe one has a financial background. Maybe one has some forensic something background. They sit with a judge.
Party people.
They sit with a judge. They sit with a judge to determine a case. If you have a tribunal, for example, where you have a judge and you have somebody like, say, an auditor, say maybe, let's say you have Domelovo there, okay? Then you have some other person with some other experience sitting in there. Don't you believe that they will do a better job than one judge who knows nothing but just the black and white letter law?
Samson, the court system allows us to bring experts to come and then give direction to the courts.
But they don't give direction. They don't make decisions.
Samson,
it's the judge who makes the decisions.
We've gone past this tribunal system.
No.
There's a lot of pain in Ghanaians who have gone through some of this tribunal system. So we do not need to remind...
And the military regime, is it not different in a democracy?
Look, Samson, that's why Professor Komunda wrote an article, Forgive Us Our Trespasses. And that's why we have all those transitional provisions under the Constitution. So that things that have happened in the past will remain in the past. Look, why don't you set a court up, special courts, to deal with lands, for instance, to deal with forests, to deal with Galamsey, and so on and so forth. You can set up courts, divisions, various divisions of the High Court, to deal specifically with...
They are already there. Those are already there.
So you should use them. You understand? I'm not sure Galamsey's solution is setting up tribunals. I disagree completely. And I think that it's misplaced priority. Look, the problem that we face right now are party kingpins, all right, who have taken over the Galamsey exercise. Look, this exercise by NIMOS, for instance, who are the people that they have been arresting? They've been arresting the little fries. How many kingpins, have been arrested so far? So the major people who are funding and running these Galamsey operations are known. Nobody has done anything about them. And then we go and bring Chamaun to me and say, what, Akunta mine? Is he the only person who probably is doing mining in forest reserves? There are people doing mining in forest reserves currently. So when we say some of these things are supposed to be, done in a partisan way, we mean it. See, a member of parliament, party chairman, there are allegations of even some regional ministers involved in this exercise. Can you take them before a tribunal to say that you want to try them before a tribunal? Look, let's work with the regular court system. I think that this issue of tribunal is misplaced. We should resort. Look, it's as if it's as if you are even indicting the current.
Let me go to Dr. Atta Kennedy. Dr. Atta Kennedy. Dr. Atta Kennedy. We have.
It is there.
We have armed men who are holding territory. Gentlemen, let's come back here. We have armed men who are holding territory in sovereign Ghana. Some of the forest reserves are no-go areas because the people there are armed. As we are told, at least 5 of them are, NIMOS cannot access them. We are told that you have as many as 2,000 people who will be there and they are armed. Sometimes they approach and they have to retreat. So my question is this a legal problem for a tribunal, or this is a security failure? Are we bringing a knife to a gunfight?
It's not a legal problem. It is a national security issue. I think that the tribunals, it's not necessarily that they are a bad idea, but they are a side issue. I'm a physician. You don't deal with the problem of lung cancer by finding good surgeons. You ban smoking. The US didn't deal with the problem of the Second World War by setting up Nuremberg whilst the Second World War was going on. They invaded Germany first before they looked for the corporals to try. They did not set up courts to try the Japanese and see whether they should go to jail. They interned the Japanese. At this stage, the key thing for the government to do is to recover those forests and those areas that have been taken over by Galamsey agents by all necessary force. Then once you pacify that and there is peace and you have people in custody, you decide where and when they should be tried. As far as I'm concerned, this talk about setting up tribunals, which, yes, is in the law and all that, I think they are side issues. It is time to prevent the pollution of our waters. It is time to prevent the destruction of our forests. It is time to prevent the feeding of mercury and other toxins to unborn children and to women. And it is time to stop the degradation of our environment. And this is the reason why we have an army. That is why we have a state. That is why we have a government. These are not things that private individuals can do on behalf of the state. It is the president and the government who must handle it, and the president must face the necessary priorities and deal with them while we all give him support. Then after we pacify everything, we can look at who deserves to be tried and where and when.
But making sure we are rounding them up in their thousands in these bushes and water bodies and throwing them into jail within 6 months is one effective way to fight it, isn't it?
It is not the effective way to fight it. It is the equivalent of talking about auditing. When you have massive corruption, you don't solve corruption with auditing. You put into place, as my friend Charles Amwasanti will say, preventive measures that will prevent the stealing, not do auditing after the stealing has taken place. We are doing the equivalent of medicine. When we are worried about a pandemic of sexually transmitted diseases, you don't look for penicillin and other things, you look for condoms, so you prevent them. The condoms are taking the forest back by force and all necessary force.
Yes, so Vicky, as I asked earlier, are we going to, a war, with a knife?
I think it's only a part of the solution. It's not the solution.
Is the problem non-prosecution or delayed prosecution of Galamsey? Is that the problem?
Oh, I think that one requires a two-pronged. There is a national security issue. That's the foundation of all of this. This is part of the solution in the sense that I think I heard the president mention there's a backlog of 1,700 cases or something of these illegal miners. So it's not something that can be ignored. So it will increase prosecution capacity, and it will also expedite these things. So that is part of the solution. But for me, it increasingly feels like we're no longer fighting Galamsey. It feels like we're actually fighting organized crime with weapons, taking territory, because these guys are taking territories now.
Correct.
And they are defying the state openly. They are not hiding. It's only the other day we were just discussing in this very studio a situation in Obuasi where the military had their camp, and then right opposite the camp, the Galamseyers are there, and they are actually encroaching into the military camp. So increasingly, it feels like we are now dealing with parallel authorities. It's an economic militia with a lot of arms and a lot of power, and it's a very dangerous combination. So it is a national security problem. And for me, I feel that as long as we don't dismantle the networks behind these excavators, i.e. the financiers, the political patrons or politicians, and the officials who are looking the other way because they are personally benefiting from this situation, we cannot win this war. We cannot. Because we need to go behind this menace to tackle it from the root. Otherwise, it's like, clearing weeds, they keep growing. We have to go to the root.
Master Planner Junior, policy analyst in Kintampo, he says that We are using a knife for a gunfight. The 2026 budget allocation to fight Galamsey is 150 million. Abnor Sayasari has asked a question about that. 150 million, but 292 million has been allocated to purchase sanitary parts. It is clear that the Galamsey fight is not a priority of the government. Rather, sanitary parts are. I'm not sure about the example you are using, though. Ghanaians are watching closely. So that's from Master Planner Junior. There's a professor who is very familiar with this area and is also worried. So he says that if I were the Natural Resources Minister getting into office, my first recommendation to the president will be redefine the scope and mandate of NIMOS, dissolve the fight to the grassroots, dissolve the fight to the grassroots, give all MMDAs, CEOs a standard KPI, failure leads to dismissal and forfeiture of central government funding, including water and forest protection directives. This is organized crime. It has little to do with mandate of Ministry of Lands and Natural Resources and so on. It's a national security issue. Therefore, the MMDAs must work with the security apparatus. Else, NIMOS will be unsuccessful and it will be most painful. Right.
A quick one. Let me just inform my senior here, which I believe you know. Godfrey Adame tried to remove the interlocutory applications during normal trials,
right,
but they couldn't finish that. So the idea you brought for that this will be removed, it's not a new thing. It's not an NDC.
For daily trials, Godfrey Adame was pursuing it.
Yes,
yeah,
so that we remove interlocutory. So please, that aspect, relax. It has always been in the pipeline. The ACDRs or whatever it is are not court systems. Let us not mix the issues. And indeed, the tribunal systems are part of our legal system. The Court Acts, the Constitution says so. But again, the punishment and deterrence is part of preventive measures for tackling Galamsey. I mean, I don't see how having daily trial, having specific duration to do trial of people who, as Vicky said, we have organized crime, cannot be used as a form of preventive. We are tackling the thing in every front. Now, I don't want to do equalization, but perhaps you are inviting me to equalize, equalize somewhere. Otherwise, I would have said, recently...
They will always say, I don't want to do it.
Yes.
Meaning they want to do it.
Yes, recently, NIMOS arrested Kingpin, and recently somebody appeared that he was...
Who?
Oh, it was in the news that they arrested someone who, even a chief, who chased them, who approached them.
They arrested did they arrest the member of parliament?
No, even that would not have happened under Nana Akufo-Addo. That a member of parliament was arrested, that would not have happened.
Members of parliament were arrested during Nana Akufo-Addo.
Who? Give me one.
But you see,
not for Galamsey, but
the issue I complained about.
Yes.
NIMOS goes there, touches and leaves.
And leaves.
The people are there. But what's the part of what it is doing, which eco-conscious citizens, Awola, Sewa and Co. are mentioning. That's my worry. You go there, the people already have had a certain organized way. A few communities, they have an organized way of preventing Galamsey. We know certain chieftains where you can't do Galamsey there because the chiefs are strong and they disallow it. Like Domahini's place.
Yes. Even Andiapia Kubi's
it doesn't happen because the chiefs are in control. Now, NIMOS has arrested some of these task forces and is prosecuting them for vigilante activity because they were caught with talisman and some guns.
Those
you want them to fight the
fighting,
Galamseyers with their bare hands?
Yeah.
You go to the community, you pick them, you do something small, you leave. The people return. And these people are there permanently. Why don't you find a way of helping them to do it properly? They just did that in Enchi. They arrested 10 of the people there and brought them. They were in custody for 10, almost 1 week.
Samson.
They went to court. They were denied bail.
Look, we can sit in this studio and you never appreciate the Galamsey situation.
I will appreciate.
Let's go to that area, Ayamfuri area, and drive from Ayamfuri all the way to the Boise area, and then you understand. Just one location.
Okay, Senior,
Samson,
Senior,
this business, it has nothing to do with tribunal.
No.
It is about declaration of state of emergency.
No. Senior.
Declaration of state of emergency will send a heightened, indication.
Yeah, let's be careful
that
about
the
state
government
of
is
emergency.
ready.
Let's be
The
careful.
president said we are not ready for.
Let's be careful about.
We are ready. Because you told us that we will come and state of emergency. Why haven't you done that?
Why didn't you do it during your time?
So now you are in charge. Why are you still blaming us?
Let me acknowledge
you are still blaming us.
Those who are paying for us.
You are still blaming us for not declaring state of emergency when you are in power.
11
months in power.
Raise our efforts.
I mean,
As strong as a group and close as a partner. MTN everywhere you go. Ashesi University, educating ethical and entrepreneurial leaders for Africa. Robert & Sons Optical Services, your comprehensive eye care service provider for 33 plus years. My Way Insurance. Dial *165# on MTN to join My Way today. Syntax stands. It's strong, it's tough. Activa International Insurance. Our clients are passion. International Facilities Management Association. They are proud to be associated with your most authoritative news analysis platform, Newsfile. Safari Valley Eco Park. It's Christmas, it's coming. That's a place you must give your family and friends the best of Christmas, bringing you closer to nature. Valex Lease, your official affordable documents management solution, and gold board jewelry. Pure, precious, proudly Ghanaian. And my outfits, if you're looking for the best kaftans, go to Habil's Couture. And in this Christmas, they have some discounts for you. So call 0200 84 1988. 0200 84 1988. My guests have been Victoria Bright, international corporate lawyer and entrepreneur. Hassan Tampoli is MP Gushon and Deputy Ranking Member, Constitutional and Legal Affairs Committee of Parliament. Theophilos Jomega is Junior, is lawyer, engineer, and member of the NDC National Communication Team. Dr. Arthur Kennedy is physician and political activist. You know him just too well. Thank you all very much for your company. And Dr. Kweku Enchibuesiakon, the former head of the cybersecurity outfit of the Republic of Ghana, wants me to let you know that he's launching a book titled The Republic, A Professional Journey, Ghana's Cybersecurity and the Making of a Role Model Country. It's on the November 25, 2025 at 6 p.m. at the British Council Ridge. President Kufuor will be there, and I also will be attending. Good afternoon. See you there.